Hi, I'm Radiance Harris, and I'm the founder and managing attorney of Radiance IP Law. Today, I'm going to share a brief overview of the U.S. federal trademark registration process. On average, you should expect the process to last about 10 months. Once you do obtain your U.S. federal trademark registration, it will last for 10 years, so long as you file the necessary maintenance paperwork between year 5 and 6 and year 10 of the registration. The first step in the process is preparing and filing your trademark application based on either current use or an intent to use with the U.S. Patent and Trademark Office. Once your application has been filed, there's about a 3-month window until your application is assigned to a trademark examining attorney at the U.S. Patent and Trademark Office. Once it has been assigned, the examining attorney will look over your application to see if there are any issues that need to be addressed. Examples of non-substantive issues may that you need to tweak some wording in the identification of goods and services, or you may have to disclaim a descriptive wording as part of the application. Substantive issues may be a likelihood of confusion refusal, a descriptiveness refusal, or it does not function as a trademark refusal, which require legal research, submission of legal arguments, and a legal brief to get around. You would have 6 months to respond to the office action. If you're able to successfully overcome any issues in the office action, then the examining attorney will approve your application for publication in the official trademark gazette. Your application will be published in the official gazette for 30 days, at which point it can be opposed by any third party who believes that they will be harmed by your registration. If they believe that they will be harmed by your registration, they can file an opposition before the U.S. Trademark Trial and Appeal Board. An opposition only determines your ability to register a trademark. It does not determine your ability to use it. Assuming you're able to successfully get through the opposition period, the next phase is that if your application was filed based on an intent to use, the examining attorney will issue a notice of allowance, to which you have 6 months to either file a statement of use, which means you're providing evidence that you've started using the trademark in connection with the products and services that you've filed for, or you can file an extension of time. You have up to 6 months extensions of times that you can use to extend your application up until the time you actually start using the trademark. In any event, you must file evidence of trademark use before you can get the registration if you filed based on an intent to use. Once you do that, your application will go straight to registration. On the other hand, if your application was filed based on current use, after the opposition phase, your application will go straight to registration. If you want to learn more, visit our website at radianceiplaw.com.